Calculating your spouse's income for the purposes of determining their child support obligation can be difficult, particularly when they are not, strictly speaking, a T4 employee. I'm Nick Slinko, an associate at the Feldstein Family Law Group. Today, I'm going to be giving you some tips and insight regarding determining your spouse's income for child support purposes. The separation process involves the exchange of disclosure regarding your income, expenses, assets, and debts. This process requires the sharing of everything from banking statements to your pay stubs to personal income tax returns and notices of assessment as well. The disclosure process can sometimes require the cooperation of individuals or groups, such as your spouse's employer or corporate affiliate, who are not necessarily directly involved in the matrimonial litigation. The legal term for these entities is non-parties. Rule 1911 of the Family Law Rules, which I will talk about shortly, deals with requesting and receiving financial disclosure from these non-parties, such as your spouse's employer or corporate affiliate. The application of this rule, Rule 1911, and the subsequent production of the disclosure sought by the spouse receiving support payments depends on 6 very specific factors. I'll go through these factors in order. Number 1. The financial documents you're looking for must be under the control of the non-party. This means that the spouse whose finances are under scrutiny does not have possession of the requested documents. This could happen in a situation, for example, where the paying spouse does not have a controlling interest in a corporation through which he or she earns an income. Factor number 2. The documents you're looking for are available only to the non-party. Essentially, there must be no other way than pursuing the non-party, for example, your spouse's employer, for you to get the needed documents. Factor number 3. All of the documents requested must be relevant and they must be necessary. You have to watch out sometimes for lawyers who engage in disclosure battles for frivolous reasons. These battles can be used as a delay tactic, or they can be designed to drive up the legal fees for the opposing party. At your end, make sure that your request for documents satisfies Rule 1911. You do not want your pursuit of disclosure to become what is commonly known in the world of family law as a fishing expedition. A common and quite effective way of establishing the relevance and necessity you need in order to get the disclosure under Rule 1911 is to hire an expert, such as a certified business valuator, in order to validate your request. Factor number 4. The documents requested cannot be subject to legal privilege. Interestingly, the documents requested can, however, be confidential in nature. Steps can be taken to produce the disclosure, which is confidential, and still protect the content of the documents from being leaked to anyone other than the spouse who is receiving the support payments, as well as his or her lawyer and potentially their expert, such as a business valuator. Factor number 5. It must be unfair to require the requesting spouse to proceed without the information sought. Measuring unfairness depends, in large part, on the factors I have already discussed, but unfairness can also be based on the likelihood of being able to calculate the paying spouse's income without having all of the relevant and necessary disclosure you are searching for. And the final factor, Factor 6, adequate notice must be given to the non-party. There's no specific timeline, but according to Rule 1911, reasonable requests should be met, and when they're not, serving motion materials in accordance with the timelines as set out in the family law rules should be sufficient. Where the cooperation of the non-parties is not forthcoming, there are ways to compel them to produce the disclosure necessary in order to calculate your spouse's income. If you are entitled to spousal support, or if you have children that should be benefiting from the receipt of child support, then it is crucial that your spouse's income is calculated properly. To that, you need proper and fair financial disclosure. Rule 1911 of the Family Law Rules and the lawyers at the Feldstein Family Law Group can help you get that information. For more details, please visit our website at www.separation.ca. For the Feldstein Family Law Group, I'm Nick Slinko.